Today we will discuss different aspects of cyber jurisdiction. Jurisdiction in general refers to a government's general power to exercise authority over all the persons and things within its territory. A court's power to decide a case or issue a decree or a geographical area within which political or judicial authority may be exercised. Cyber jurisdiction or jurisdiction in cyberspace refers to a real world's government's power and a normally existing court's authority over internet users and their activities in cyber world. A significant reality is that net users and the hardware they used are never virtual but have physical presence in one country or the other upon whom the jurisdiction can be exercised, and such jurisdiction is called cyber jurisdiction or jurisdiction in cyberspace. First, we will discuss what jurisdiction means. Jurisdiction means the authority which a court has to decide a matter that are litigated before it or to take cognizance if matters are presented in a formal way for its decisions. It could be said that it is the power, authority of the court to decide matters that are brought before him. In this context, jurisdiction over activities on the internet has become a battleground for the struggle to establish rule of law in the information society. The rise of the global computer network is destroying the link between geographical location and the power of the local governments to assert control over online behavior. Another one is the effect of online behavior on individual or things. Then the legitimacy of the efforts of a local sovereign to enforce rules applicable to the global phenomenon and ability of the physical location to give notice of which set of rules to apply. The net thus radically subverts a system of rule making based on borders between physical spaces, at least within respect to the claim that cyberspace should naturally be governed by the territorial defined rules. The internet explosion has generated many jurisdictional disputes, putting the onus on the courts to determine how to apply historic concept regarding personal jurisdiction to the boundaryless world of the internet. With so many outsourcing activities in India and the popularity of networking websites, a fresh number of cases related to personal victimization and economic offences in the nature of data protection, cyber defamation, security, etc. have evolved. Cyber jurisdiction is still in the stage of development as a legal concept, as internet has led to disappearance of the boundaries. Sometime a netizen is not aware with whom he is chatting and where a person is located. In such a situation, if a legal dispute arises between two persons communicating on the internet, then which court will have jurisdiction to decide the case is still an issue that is yet to be resolved satisfactorily. In other words, there must be a law that should provide whether a particular event in cyberspace is controlled by the laws of the state where the website is located or by the law of the state where internet service provider is located or by the law of the state where the user is located or by any specific laws. In contrast, real world is a physical entity with well-defined border dividing it into sovereign state. It functions on the basis of sovereignty of state over its territory and individual. The principle of territorial jurisdiction is accepted in the real world, which is based on the mutual respect of sovereign equality between states and is linked with the principle of non-intervention in the affair of the other states. Another aspect of the principle is that in case a state wants to enforce a particular law beyond its geographical boundaries and try a citizen of another state, then it has to take the permission of municipal court of other state to get the accused extradited. Whereas there is no law or international instrument relating to jurisdiction in cyber world or cyberspace, which is the virtual space between two modems or where internet is located. This electronic territory does not occupy any physical area except the hardware, telephone and wires. In internet or cyberspace, information is broken into small bits which can be transmitted according to the available capacity. These packets are labeled with the address of addressees and may follow a number of different routes from computer to computer until reaching final destination, where the receiving the computer reassembles them as these were originally sent. As internet uses packet system of transmission having different nodes situated in different contents, so any single state cannot claim that any activity has entirely taken place within its borders so that it can have jurisdiction over it. Now we will discuss briefly on cyber law and jurisdiction. In cyber world, every state should have its national law having extraterritorial jurisdiction to cover extraterritorial character of cyberspace activity. As there is no international instrument relating to cyber jurisdiction covering this aspect, among others, the United Commission on the International Trade Law adopted a model law on e-commerce in 1996, which was adopted by the General Assembly, recommended that all the states should give favorable consideration to the said model law on commerce. India, being signatory to the said model law, enacted the Information Technology Act 2000 to make it law in tune with the said model law. One of the biggest drawbacks of the model law on e-commerce and Information Technology Act 2000 is that these are silent about the jurisdiction of the courts in the cyber world. Therefore, in present scenario, an important question is whether present law of jurisdiction of physical world is applicable to cyber world or a separate law is required. Regarding this, there are following two views. If the two words are not related, then a separate law of jurisdiction is required for each. Another one is, but if there is a strong connection between the two, then with necessary modification, the existing law of jurisdiction of the physical world can be applied to both. Argument in the favor of first view is that physical boundaries have disappeared in cyber world. Therefore, physical world and cyber world are not connected. Hence, a separate law of jurisdiction is required for the cyber world. However, this view does not appear logical because though in cyber world there are no geographical boundaries, but still in physical world these boundaries are existing. Further, because of the various reasons, it's not possible to develop separate law of jurisdiction for the cyber world. Argument in the favor of second view is that though in cyber view world there are no geographical boundaries, but netizens are citizens of some countries and they are governed by their national law of those countries. Therefore, physical world and cyber worlds are connected and hence present a law of jurisdiction of physical world with minor modification can be applied to cyber world. This view appears to be illogical. It means the present law of jurisdiction of physical world with the minor modification is applicable to the cyber world as well. Now we will discuss what are the types of cyber jurisdiction. Problems regarding cyber jurisdiction is faced in the following cases or matter. The one is cyber jurisdiction in national cases. It can be of following two types. One is cyber jurisdiction in civil cases and cyber jurisdiction in criminal cases. First, we will discuss cyber jurisdiction in national cases. Cyber jurisdiction in civil cases. Cyber jurisdiction in civil matters mainly comes into picture when a website or any information hosted on the internet leads to commitment of a civil wrong in an other state. In deciding whether jurisdiction exists over a defendant, the US federal courts apply the law of the states subject to the limits of the due process clause of the 14th Amendment. This is illustrated in the following cases. McDonald versus Felon. In this case, the defendant from outside California created a website which was accepted by a Californian. Subsequently, a dispute arose and the matter had gone to the federal court. In this case, the federal court in California also refused to exercise personal jurisdiction over the defendant. Simply because it maintained a website, the court held that fact that defendant had a website assessed by the Californian was not enough by itself to establish jurisdiction. Then cyber jurisdiction in criminal cases. Initially, cyber jurisdiction was an issue in the civil cases only, but in 1996 in US versus Thomas, cyber jurisdiction became an issue in the criminal cases also. In this case, defendant operated a pornographic bulletin board from their home in California in 1991, which was accessed by the members having password, which could be selected, retrieved and downloaded on their own computers. In an appeal, the US District Court, Tennessee upheld the conviction under the statute which prevents the channel of interstate commerce from being used to obscene matters. The court applied contemporary community standards as were done in Miller versus California, explaining the obscenity was to be judged by what the average person applying contemporary community standards would find to be obscene, and in this case the matter was not obscene under the California Bay Area standards but was so under the standard of Tennessee. The court applied the standard of geographical area where the material was sent. Defendant argued that internet environment provides broad ranging connection among people in cyberspace. As such, the notion of obscenity tied to a geographical locale would put a chill on the protested speech. The defendants asserted a more flexible definition was needed because BBS operator could not select who received their material. Then we will discuss cyber jurisdiction in international cases. In this particular thing, we will discuss the case of Playboy Enterprises versus Frene. The defendant operated a subscription electronic bulletin board which downloaded the unauthorized copyrighted photographs of the plaintiff. The court held that unauthorized uploading of the photographs by the defendant, knowing that they could later on be downloaded by the subscribers, amount to distribution. In Asahi Metal Industry Company versus Supreme Court, the US Supreme Court gave the principle of higher jurisdictional threshold when defendant is a foreign national as compared to when he is a US citizen. Here, the defendant's headquarters was in Japan. The court refused to exercise the jurisdiction due to the following reason. The one is the distance between defendant's headquarters in Japan and Supreme Court in California, and burden of submitting a dispute between two foreign nationals in a foreign legal system. Second one is California's and foreign plaintiffs' slight interest in having the case heard in the California. Then the effect on the procedural and substantive interests of other nations by California's assertion of jurisdiction over a foreign national. Then we will discuss present relevant legislation in India. The very first and important one is Information Technology Act 2000. In this, Section 75 of the Act implies that the Act shall apply to an offence or contravention committed outside India by any person if the act or conduct constituting the offence involves a computer system or computer network located in India. In India, Section 75 of the Information Technology Act 2000 provides extraterritorial jurisdiction to the Indian courts, as often need to assume jurisdiction over foreign subjects would arise with the increase in activity on the internet. However, Section 75 has its own inadequacies and may not prove to be effective when it comes to its actual implementation. For instance, Section 75 appears to be ineffective on the ground that if an act is an offence or contravention under this act and is committed by a person from outside India and which is affecting any computer or computer system or computer network in India, and that act is not an offence in that country, then any judgment passed by an Indian court may not be enforced by the court of that foreign country, because that foreign court may not accepted the principle of extraterritorial jurisdiction as given under Section 75, as that act in that country is not considered unlawful. Then we will discuss the provisions under Indian Penal Code. Section 3 and 4 of the acts deals with the extra jurisdictional power given to the Indian courts. Under Code of Criminal Procedure 1973, E section 188 provides that even if a citizen of India outside the country commits the offence, the same is subject to the jurisdiction of courts in India. In India, jurisdiction in cyberspace is similar to jurisdiction as that relating to the traditional crimes, and the concept of subjective territory will prevail. Moreover, Section 178 deals with the crime or part of it committed in India, and Section 179 deals with the consequences of crime in Indian territory. When an offence is committed within the jurisdiction of court, Section 177 will apply. Every offence shall be inquired into or tried by a court within whose jurisdiction it was committed. Where an offence committed at more than one places, etc., Section 178 will apply. Where an offence is committed in more than one place, or where it's continuing and continues to be committed in more than one local area, or where the offence consists of several acts done in different local areas, then it would be inquired into or tried by the court having jurisdiction over either of such areas. Where it is uncertain in which of the several areas the offence is committed, Section 178 subclause A will be applied. It may be inquired into or tried by a court having jurisdiction over either of such areas of uncertainty. Where an act is done and consequences are produced, Section 179 will apply. Where an act is an offence by reason of anything which has been done and of a consequences which has ensued, it may be inquired into or tried by a court within whose jurisdiction such an act has been done or such a consequences has ensued. Where an act is an offence by the reason of its relation to any other act, Section 180 of the CRPC will apply. Where an act is an offence by the reason of its relation to any other act of which would be an offence if the door was capable of committing an offence, the first offence may be inquired into or tried by a court within whose jurisdiction either of the acts was done. Then we will discuss certain specified offences which is defined in section 181. Certain specified offences have been required by the law to be inquired into or tried in certain places. Any offence which includes cheating. Section 182 defines any offence which includes cheating if the deception is practiced by means of letter or communication messages may be inquired into or tried by the court within whose jurisdiction such letter or messages were sent or where the same were received. Any offence of cheating and dishonestly including delivery of property may be inquired into or tried by the court having jurisdiction on the place where the property was delivered by the person deceived or where it was received such letters or messages were sent or where the same were received by the accused person. Then we will discuss section 186 where it has defined where two or more than two courts take cognizance of same offence. If two or more courts take cognizance of the same offence and question arise as to which of the court have a jurisdiction to inquire into or try that offence, this question would be decided by the High Court under whose jurisdiction both of such courts function. Where courts are not subordinate to same High Court, the question of jurisdiction shall be decided by the High Court within whose appellate criminal jurisdiction the proceedings were first commenced. In a leading case of cyber crime, Pneumatic India Private Limited versus Jogesh, the first case of cyber defamation, High Court of Delhi assumed jurisdiction over a matter where a corporate reputation was being defamed through emails and passed an important ex parte injunction. The concept of consequences and cause of action extends jurisdiction, but a conflicting situation arises where there is no defined regulation at one of the places. For example, the Act does not provide any provision to catch the internet pornography on foreign website, but only for the sites in India. The Supreme Court in India, in the case of Import versus Exim Aid Silk Importers, has recognized the need of the judiciary to interpret a statute by making allowance for any relevant technological change that has occurred. Until there is no specific legislation in regard to the jurisdiction of the Indian courts with respect to the internet disputes, or unless India is signatory to an international treaty under which the jurisdiction of the national courts and the circumstances under which they can be exercised are spelled out, the Indian courts will have to give wide interpretation to the existing statutes for exercising internet disputes. In concluding remarks, I must say in the present scenario where the cyber crimes are increasing to an alarming extent, the present need of an hour is to have a broad-based convention dealing with criminal substantive law matters, criminal procedural question, as well as with international criminal law procedure and agreements. The IT Act 2000 would be crippled without proper means and ways of implementing it. To overcome the difficulties, the necessary amendments must be made to the Code of Criminal Procedure 1973. Moreover, it's important to note that India at present does not have a proper extradition law to deal with the crimes that have been committed over the internet. To address this issue, India should become a signatory to the Convention of Cybercrime Treaty and should ratify it. This move would go a great deal in resolving the jurisdictional controversies that may arise in cybercrime cases. cyber jurisdiction is still in the stage of development in law, and lot needs to be done fast in this area due to manifold increase in the economic and other activities in cyber world, at times illegal in nature, impacting almost every country in the real world. Cyber jurisdictional issue need to be sorted out in national law, as well as uniformity in laws need to be brought about in such cases, and more importantly, not let the cyber criminals go unpunished due to gaping loopholes in existing law or due to the absence of law. Altogether, covering such matters both at national as well as international levels. Due to inadequacy in the national laws, quite often ticklish legal situations arise in jurisdictional matters related to the internet, and national laws are found wanting. Many times, case laws has shown that for personal jurisdiction, a court requires that a defendant must provide more than mere accessibility to a website, or some sort of interaction should have been there, whereas the web creator or the information provided has to comply with the law of the state where user is located and becomes to the user state jurisdiction and law. Thank you viewers for watching this program.